So good morning and welcome. My name is Berna Kiskindemer. I'm a senior advisor on AI and algorithm oversight at the Dutch DPA, Autoriteit Persoonsgegevens. And I'm very happy today to moderate this panel on fundamental rights impact assessments in practice. Appreciating their ability to bring in and bring together such a broad range of stakeholders and expertise, we wanted to facilitate this conversation this year at CPDP, as it comes at a time where we ourselves are in the midst of the preparations for joint oversight on the EU AI Act in the Netherlands. And within that context, we've also started engaging on operationalization on the FRIAs. Why are we engaging on this topic? Just also as a quick reminder, under the EU AI Act, deployers in the public sector of high-risk AI systems will be obliged to conduct a fundamental rights impact assessment and report this to the relevant market surveillance authority. But also providers will have to some extent, assess and be able to mitigate risks, including to fundamental rights under Article 9 of the EU AI Act. So seeing these obligations related to the FRIA, in relation also to the task and powers given to the MSAs, we also have a role in translating this legal obligation into operational expectations, really. So then the question becomes, right, what makes a good FRIA? How can they be operationalized effectively across sectors, regulatory frameworks, but also in a way that actually amplifies innovation efforts? But also, how do we ensure that they remain meaningful safeguards for people's rights rather than becoming merely ticking box exercises? And sometimes all these things might seem in opposition to each other. What's the tension there? So hopefully we'll be able to gain some insights on this. I'm delighted to be joined by three distinguished speakers who each bring in valuable perspectives and expertise to this conversation. We have Dr. David Reichel. He's the head of the data and digital sector at the European Union Agency for Fundamental Rights. Next to him sits Karolina Iwanska, senior legal advisor at the digital team at the European Center for Not-for-Profit Law, ECNL. Last but not least, we have Harshvardhan Pandit, who is a research fellow at the AI Accountability Lab, Trinity College in Dublin. We also have a special guest in the audience, Mr. Milanos from the European AI Office. After the conversation, he will have a short intervention giving some updates, recent updates from the EU AI Office. So thanks also for being here. We, of course, would also love to hear from you. So after that, there will also be some time to share your insights or pose some questions you might have. And so let's get started. Leading to my first questions, even though the legal obligation is, let's say, relatively new when it comes to fundamental rights impact assessment in this context, there is, of course, a lot of methodologies already in place, tested. So from the Netherlands, we have the IAMA, of course, who also recently got republished with the learnings. But we also have the Montelero framework on the FRIA. I think that says enough for everyone interested in this topic. But the Hudera framework from the Council of Europe, and many more relevant research that has been done, including the FRA, recent report on assessing high-risk AI systems. So keep having this in mind. I guess my first question for this first round is, what makes a good FRIA? David.
Thank you, Berna, for the floor, and to the Dutch Data Protection Authority for inviting us to this panel discussion, which I think, of course, addresses a very important topic. As we discussed previously before, it's also not a new topic as such. I think Carolina said it was discussed in this room a year ago, and we actually work on this for quite many years now. So I also brought here our report from 2020 called Getting the Future Right, where on page 95 or so, I think, we outlined the main elements of how you assess fundamental rights when using AI. We have a booth down there, so you can also get all our reports, and I encourage you to do so. But of course, the discussion is evolving, and what makes a good FRIA? A good FRIA helps to protect fundamental rights. It prevents fundamental rights violations. That's all what it is here for. How to do that? As I said, there's a lot of knowledge about this already out there. It starts with an understanding of what fundamental rights are in the context of use of AI. So you need to have an understanding of both the way the AI works, but also what fundamental rights interferences mean. In our most recent report, it's called Assessing High-Risk AI, also available downstairs for free. We, again, based on interviews with deployers and providers of AI in high-risk areas, asking about their understanding. Here it's on page 58, where we outline the key main elements of a fundamental rights assessment in practice. So there are 4 steps, and I think there's quite some agreement on what it has to include. It always has to start with a good description of the system. You really need to know what's going on. You need to identify the people that are affected by the use of a system. And then you need to look into the assessment of adverse impact on fundamental rights, considering the mitigation measures you have in place. And then the final assessment, like, is it really necessary to interfere with fundamental rights to achieve my goal? And is this also proportionate? I think you all know these kind of basics. While there's a lot of important discussion about the process, like how this should look like, I think we always need to remind and look into the content of fundamental rights violations when using AI. And what we always advocated for is you have to start somewhere. So ideally you start with checking your data protection requirements. That's already well regulated, as you know, because AI is a bit of a game changer. You know, if you have a CV sorting AI system, for example, it may pick on information in your free time and determine your sexual orientation. That's what you don't want to see, because AI is just much more powerful than a way systems were processed before. The second is equality and non-discrimination. We all know that AI can quite easily be biased. A recruitment system can easily pick then on certain information that it determined and then put people at a disadvantage. And that's for sure to be looked into closely. And the third area we like to highlight is access to an effective remedy. Whenever you make decisions with the use of AI, people can challenge those decisions. And if you're challenged, you just need to be in a position to explain how you arrived at certain decisions, because you cannot say in certain contexts, oh, the AI said that, we don't know. Because that does not provide for equality of arms in court. And lastly, depending on where you use AI, because you always have to understand the context, other fundamental rights may be impacted on. And yeah, there is, of course, important guidance needed, like in what use case, what rights may be impacted on. So a good FRIA, as a due diligence exercise, seriously looks into these aspects. We know from our research that this is not always happening in practice. There are a lot of good-willing companies that try, but just don't really know what fundamental rights are and what to do. Others also just don't try. And that's why, of course, it was clear that regulation is needed. And we'll talk in the next round, I guess, also more about I will talk about the regulation and how this can be applied to do good fundamental rights impact assessments. I just want to add one last point, if that's okay time-wise, because we had it in the title also, like how FRIAs support innovation. While, of course, it's against the law to violate fundamental rights, I think we still have to improve to actually make the case for businesses that actually testing for fundamental rights makes better tools, makes better AI. Because if you have an AI system that, for example, a recruitment algorithm that simply prefers men over women, it's not a good recruitment algorithm, right? It's discriminatory, that's wrong, but it's also not a good one. It doesn't help the business in the end. If you have a system that you actually don't understand how it arrives at certain decisions, that's also not good for a company, because it can go really in a wrong direction that no company wants to see, apart from the fact that that's not okay if someone is challenging that. Yeah, so I think it is not just needed to protect fundamental rights, but it's also making better tools, better AI, and that's the competitive advantage of Europe that we have to keep. Yeah.
Thank you. Moving to Carolina, ECNL also actually around the same time. December 2025 was a very fruitful month for the FRIAs, I guess. But you, ECNL, together with the Danish Institute, also published a guide on how to conduct fundamental rights impact assessments. Could you share your reflections on what makes a good FRIA.
Thank you so much for the invitation. I don't know what's up. Thank you so much for the invitation to be on this panel. I agree with David that the ultimate purpose of FRIAs is to prevent fundamental rights violations, but I would make it even more granular in the context of regulatory impact assessments where that are part of compliance process essentially. So to me, there are maybe four main purposes of FRIAs. One is for the AI deployer themselves. So what you said, right? It's like how it's an opportunity to have a process of reflection on what potential violations could occur with this system and actually prevent them from happening. But then importantly, for people who are affected by this system, this process is also an opportunity to have a say and an opportunity to raise their concerns about how they will be impacted by this system, which no deployer can do alone. Like they need to consult people in order to go outside of their bubble and understand what in practice that system, how it in practice can affect people. Then for civil society watchdogs, the FRIA process is a crucial moment of accountability. So even if, I don't think FRIAs are a silver bullet necessarily for preventing all the harms, especially when we look at the practice of other impact assessments that hasn't been very optimistic on that front, at least it is a source of information that shows what the institutional organization has done to address the risks and to also spot gaps in addressing those risks. So it's a crucial element of accountability. And then finally, for market surveillance authorities, of course, again, it's a source of information that is needed for effective supervision of whether there are no fundamental rights harms. So I mention all that because to me, a good FRIA is one that is designed in a way that makes it possible to fulfill all of these purposes. So what does it mean in practice? I will not actually go super much into the detail on the process because you can read all of that in our guide to FRIA. And then as we discussed previously, there was a panel on this last year. There was lots of discussions already. There's lots of methodologies that go into the detail of the actual process. But what I wanted to share today is a few lessons learned from other impact assessments under the GDPR, the systemic risk assessment under the Digital Services Act, which is also irrelevant, that doesn't necessarily come up when we discuss the AI impact assessments, but it's also bringing some useful lessons. So the first lesson for me is a FRIA will be good if there is a clear responsibility chain for who is responsible of signing off of decisions around this AI system. And that requires involvement of high-level decision makers. So often the practice from various impact assessments is that some civil servant is, tasked with conducting the impact assessment, but they don't actually have the political power to decide, are we going ahead with the system or are we not going ahead with the system? Most likely the decision has already been made by the minister and then the FRIA serves as a tick box exercise. It cannot, if we want a meaningful FRIA, it cannot be the case. The political level has to be involved and sort of has to buy into this process from the very beginning. And we have to recognize that these choices are not, they're not technical, they're political. The way that you assess, whether a certain impact on fundamental right, is it proportionate, is it necessary? It's of course a legal assessment, and that's gonna be my next point, but it's also a political decision ultimately. Are you accepting that risk? Are you accepting that perhaps you will be violating fundamental rights or not? And somebody has to sign off on this. The FRIA should end with, and the FRIA process should end with the decision on are we deploying this in light of these impacts and how we mitigate them or not. And this decision has to be clearly documented, in my opinion. So that leads me to the second point, that a good FRIA is grounded in human rights and is grounded in the decades of expertise of human rights impact assessments. There are existing methodologies, there are existing expertise around that. And something that we were discussing is that actually human rights expertise very often is considered not relevant in that process or less relevant that, for instance, including technologists in that process. It has to be inherently an interdisciplinary process. You really have to have that expertise as well. And we do see from practice that there is lack of even basic understanding of fundamental rights. What do they mean in a specific context? So for sure, there needs to be much more training, much more investment in understanding that. then FRIAs, they need to come early enough to actually be able to influence the outcome, how the system works. Very often when we are in a compliance setup, FRIAs or impact assessments are treated as a compliance document that comes at the end when nothing can be changed anymore. That is not how a meaningful FRIA should work. And the consideration of fundamental rights should be an organic part of the development and deployment process. And here also collaboration between the provider and the deployer, especially in the public sector context, when a lot of the systems are procured from the private sector, that has to be embedded from the beginning and not an afterthought, when we're preparing to launch the system and oh, wait, we need to do this document. And then the last thing is a lesson that I want to share from the Digital Services Act. And I wanted to ask for a show of hands if anybody has seen the reports that big online platforms publish of their assessment of systemic risks, including on fundamental rights. Has anybody seen? Okay, a few people have seen it. So I really encourage you to take a look, because they are useless. So, there are 120 pages of nothing. And that is a very important lesson, I think, when we made a choice, and the legislator for most AI systems made a choice that summaries need to be public. There is an incentive not to say anything to the public in the compliance mindset, I think. You don't really want to show too much, because then you're kind of offering yourself up for criticism. So it will be extremely important to actually define what goes in this summary so that it's meaningful and not, 150 pages of blah, blah that we have to go through every year with the DSA. And last comment, and then I stop. We also need in the FRIAs actual evidence of how the deployer arrived at the conclusions that they arrived at. So justification, some insight into how they arrived at these conclusions and what changes have been made in the system as a result of these conclusions. That is also a very important lesson from the DSA, because we're not seeing that. The companies are not providing any evidence, any data, any clear information of what has changed. So that if we are serious about making FRIAs work, we need to learn from these lessons, also from the GDPR lessons, and make sure that this is all embedded in the process.
Thank you. Harsh, your research aims to understand the complexities that occur at the intersection of law, rights, and knowledge modeling. And in that context, you have also been researching impact assessments. What makes a good FRIA from your insights?
Thank you, first of all, to Barna and the Dutch DPA. And also, I'm very happy to sit alongside David and Carolina, because I think they said most of the things. So I'll be your human summary for today instead of the AI summaries. So a FRIA as something that is good is very subjective. So instead, what I will discuss is what is an effective FRIA, because then we know that it's effective for something. And I think that FRIA as a legal measure has uses beyond just the legal obligation. So there's three things. The first is when an organization doesn't know what to do or what should happen. So the FRIA is effectively a framework for them to understand what are they trying to do, what is their purpose, like what is going to happen or what is not going to happen, and how is it going to affect the specific people. And it also is information about the system that they're trying to use. Do they understand it enough? So without any of these things, you obviously cannot do an impact assessment, but sometimes, or rather in most of the times, we find that organizations don't fully understand things, either because there's a lack of expertise or because they just haven't thought things through. So the FRIA is a structured framework that gives you ideas on how to think about it and how to understand what you're trying to do, what you have, or what you may not have. After that, the FRIA becomes a method of implementation through which you can investigate what are going to be the consequences if you continue on this current road. Is it going to work? If yes, to what extent? Where might it not work? Are there edge cases? Who might be affected? When might be affected? How long is that effect going to last? So at this stage, it starts resembling risk assessments more, but we have to remember that FRIAs are about fundamental rights, not necessarily about the organization's risk. So it requires that external perspective at all times. So, it's the ability of this organization to approach how is my thing or my process or what I'm trying to deploy going to affect actual people. And then you want to see that, okay, if this happens, what is going to be the impact on rights? So I think it's a little bit scary when we directly say, oh, are you violating rights? Because I don't think most of us are comfortable enough to directly assess whether rights are being violated. But I think relatively it's easier to discuss like, oh, when is the system not going to work? And what is going to happen to the people who may be subject to the system or who are dependent on the system? And then what are the consequences or effects on rights? So the FRIA is this journey of going from what you know to what you may not know and want to know. And after that point is the most important bit, which is that the FRIA is basically the ability for an organization to make justified changes. So you can point to something and say, look, if we do this, these are going to be the problems and we need to change, we need to fix something, or that this is unfixable and we shouldn't do it. Unfortunately, at an organizational level, you require evidence, sometimes to justify that, oh, no, we shouldn't go ahead. It's not just about the money put in, it's about now impact on fundamental rights. Or could also be that if we do this, we are going to get sued. So you never know, until you get to that point. But more importantly, FRIAs are not a checkbox exercise. You don't do them at the end when you've finished deciding everything. You do them early enough so that you identify what you don't know, and then you try to find out whether you can provide this information, whether you need to go to the vendor to get this information. So at some point, the FRIA also occurs, or rather informs your procurement processes or your development processes. And to me, that is an effective FRIA if it can influence or to assist you in making these changes to the way that system is being developed, deployed, or even used in practice. And all of this influence is what gets codified as organizational policy. So a good FRIA eventually will become organizational policy, and then it will basically be a good documentation of what you have done, because now you don't need to use the FRIA to learn something.
Thank you, all three of you. So some of the things that all of you said, procurement processes. But I think that's also a message maybe for intended deployers and providers, the collaboration between those two. I also heard the FRIA as a due diligence exercise. Carolina, if I may come back to you, because you already started mentioning lessons learned from other impact assessments and the other regulatory frameworks. What other practical aspects regarding the operationalization of the FRIA also among sectors, but also these other regulatory frameworks do you see? Because often we also hear, and maybe to some extent rightfully so, that there is maybe an overregulation going on, or that a lot of assessments look the same, or it's burdensome. Could you reflect a bit more on that?
Yeah. So it's true that this often comes up, that that FRIAs and similar mechanisms are considered a burden. They're considered a painful and annoying obligation that you just need to get done before you launch a system. But I think, we recently discussed this with some other people that, would in an airline industry, would you actually say the same about safety experts? It's unimaginable not to have, safety experts and that process being taken seriously. So what would it take for the same mentality, the same perspective to take place when we're developing AI systems, especially high-risk AI systems? What would it take to internalize that these assessments are important and to make them part of the organizational culture, what you said at the end of the day? One thing is that I think when we talk specifically about fundamental rights impact assessments from the AI Act for the deployers, they are primarily going to affect public sector institutions. And I think public sector institutions do not realize the power that they have in the procurement process context, where they literally can, if they don't feel they have the expertise or that they have the resources to conduct a fundamental rights impact assessment, why not include that as part of the procurement process? Why not sort of throw that burden on the provider or whoever is submitting their tender in the procurement process to give you a package deal in a way, to give you the system and assistance in assessing fundamental rights and consulting people. This is already slowly being done in some cases, but I think this is a severely underexplored area. It doesn't necessarily have to rely on people who are within the public institution. So I think access to fundamental rights expertise is one practical consideration that needs to be taken into account, because we all say that that is important, but it is true that that expertise, it exists in civil society, it exists in national human rights institutions, it exists in academia, but it doesn't necessarily exist in like traditional compliance companies or law firms or auditing firms. Like they claim they have fundamental rights expertise, but they don't really. So how do we tap into that expertise that already exists is a question. There are ideas around, maybe creating a pool of experts that could be available for municipalities or public institutions that are deploying this system. So that's one kind of practical consideration that I think would benefit from more conversation. How do we actually make that expertise available? That's one thing. And then, Berna, you asked about the intersections between different regulations. So those of you who are following the AI Omnibus might know that there is a new provision in the AI Omnibus that aim to clarify the relationship between fundamental rights impact assessments and data protection impact assessments. I don't think it necessarily clarifies anything, but there were unfortunately calls during that process to actually completely remove fundamental rights impact assessments because DPIAs already cover everything, which is completely not true in practice. It's very rare that data protection impact assessments actually address the whole spectrum of fundamental rights, and that is, they of course can. I really do not think we should do too many assessments if we can, kill the bird with two. Kill the what was the saying ago? Exactly, sorry. 2 birds with 1 stone. That's a very violent expression. I want to use it. So I in general, I agree with this direction that the Omnibus has, where you can cross-reference the data protection impact assessment in your FRIA, but that doesn't replace the fundamental rights impact assessment. But then, of course, what does it mean in practice? I really would like to avoid the risk that deployers just say, see DPIA. For the obligation of fundamental rights impact assessments. Of course, a lot will depend on what is actually required in the FRIA, what is required in the reporting template of the FRIA, in the summary. But I do think, for instance, for the right to data protection, that those elements can for sure be covered by the data protection impact assessment and referenced in the FRIA. So there's no need to conduct, a separate assessment on that front. But FRIA still does have an important additional value of looking into the rights that normally you wouldn't look like. So for instance, recently we ran a workshop where we were putting people in a position of trying to come up with rights impact scenarios for a system that was inspired by a system used in the Netherlands for assessing risk during the probation process. And interestingly, we sort of encourage people not to look at data protection and not to look at non-discrimination, because these are the sort of obvious rights that often come up, but look beyond. And it was so interesting to see how, we were looking at the right to free trial, the right not to be, tried twice for the same crime. So these rights that I think are not often talked about in the context of AI, but are definitely impacted. The right to good administration, there's a lot that has been recently published on that topic. So I think FRIAs have a super important role in literally going through the entire list of fundamental rights from the Charter and, step by step seeing whether my system can have impact on those. Yes.
Thank you. Sorry. Please let others have something to say. Kidding. No. I mean, all valid points and clear very much. Thank you. I do sense a little tension there because earlier on, we also said, well, it's important to just get started, and these are the 3 main, and then per sector you can look into what most pressing rights there could be. I think this was also, David, something that you mentioned. Thank you for this perspective. David, if I may come back to you. So I think also had some good discussions on the whole notion around probability, severity, and how legalese that should be, or what's the real purpose. And you briefly mentioned it as well. And then to come back again, because I asked Carolina about the challenges on operationalization, but dare I maybe ask, are there also opportunities with the systems that we already have in place, or from your work or research that you have seen, that could also actually so the challenges and the opportunities in the operationalization of the FRIAs.
No, thank you. I'm afraid there's not much tension, although tension would be good. But I think there's agreement. Of course, what I said is that you have to start somewhere, right? But you, depending on the use case, have to look into other fundamental rights for sure. So where we go from here, in the first round, like speaking what is a good FRIA, now we have several laws in place that require the assessment of fundamental rights when you use AI. First of all, we have the GDPR. We already heard there's the data protection impact assessment that, if done properly, already solves a lot of issues. A lot of focus is on the AI Act, of course, but as we heard before, there's also the Digital Services Act. We have non-discrimination law and so forth. So a lot of things require these assessments already. In the AI Act, of course, there's much focus on Article 27, but there's more risk assessment of fundamental rights in the AI Act. As you know, for providers, Article 9, the risk management system, and that was at the beginning what we read as the fundamental rights impact assessment. But then, of course, Article 27 was also added for certain deployers where fundamental rights need to be assessed. But then we also have Article 10, where you have to look into data management and biases, which is important for fundamental rights protection. Article 11, I like a lot, technical documentation. That's really important for the transparency that is needed when you use AI. There's Article 14 on human oversight, Article 15 on accuracy. And of course, there's also the tricky Article 6 filter, where you also have to make an assessment how the system impacts decision making already. So while it's important, of course, to critically engage with law, it's also important to use the tools we have in law to protect fundamental rights. And we heard enough that guidance is needed, and a lot of good guidance is already there. It was mentioned by you, the Council of Europe guidance on Huderia, the ECNL tool is really great, the Dutch model that was developed some time ago. We have the academic guidance. I see Professor Mantelero at the end of the room providing a very good guidance there, and many, many others. So I wouldn't do justice actually start listing them. But now concretely that we have the law, there are different places where we go from here. One is the technical standards that are developed for providers in relation to risk assessment. That's under Article 9, so that the European technical standardization organizations called CEN and CENELEC that are currently working on technical standards. And that's the first place where fundamental rights risks need to be assessed, and an important part to engage in. It's not only a risk management standard, there are also other standards on bias and data sets that are quite relevant. Then, of course, there's the FRIA template to be developed on Article 27. The AI office are working on that. We're happy to work with the AI office on that. And if you read through, it's actually quite clearly outlined in there what it should contain. Letter A to F, it includes a description. You have to describe the groups affected, the risks of harm, oversight, and what you do when risks materialize. But of course, letter D of paragraph 1 is then the central piece, like how do you assess the risk of harm in practice. And then that was also mentioned before, what is of course important for the practical operationalization, as you were asking, is the complementarity that is also mentioned in the AI Act. And yeah, I don't want to talk about killing birds with stones. But of course you don't have to assess the same thing twice. And then is the question, and I actually agree, so in theory, a data protection impact assessment, which you have to do, should look into other rights and freedoms. So in theory, it would be nice if someone already looks into a lot of other rights. The whole charter are already there. Some claim to do so. I also haven't seen many. But if it's done, then by all means, you can use this information and refer to it. But in order to ensure that other fundamental rights are looked into, that's where this requirements in the AI Act come in. And then it's the provider. You need to see, do you have a good provider actually who really did a thorough assessment already? That's great actually. And according to Article 13, they have to provide some information to the deployer who would then have to do a FRIA in practice. And that you can also already draw on. And I also hope the market will do its work, and that good providers come up and say, look, we have all the documentation you need, and so buy our product because it's very much fundamental rights compliant. Yes, but just for maybe the last point, because I'm aware of the time. So I actually think assessing fundamental rights is sometimes much easier when you have AI, because AI is actually data processing, right? And because before proving discrimination without any AI, is really difficult in practice. With an AI system, you can actually look for biases. So we have some kind of opportunity there. However, when we speak also in a confidential manner in our research, we always assure anonymity to the companies we talk to, because usually they don't want to talk about their AI systems. And often they also cannot tell us about a lot of things, like what data they used, how the system works in practice. And I just don't really know if they don't want to give the information away or if they really don't know how the system works. And I think that's an important difference, and also like how you go about when you just don't know the system. And that's for sure a big risk in practice that we need to see. But the end goal for sure is, and that's also what you mentioned, I think, of a FRIA is also to ensure transparency that is then used by oversight bodies to look into and see, like, did they do that due diligence.
Yeah. Thank you. I'm also hearing, so a FRIA for deployers could be much more easier if the provider does his job well, I guess. Okay, this comes back to the procurement issue that was mentioned before. And I also thought it was interesting that you said that how this also use of AI systems gives the opportunity also then to kind of like make discrimination more tangible and see where to fight against it. I think that was something interesting, an interesting perspective to this as well. But then it's maybe even more important than that this transparency is there, but also maybe a certain vulnerability of organizations being able to say, sorry, we really don't know what to do with this, but we do need something like this. So thanks very much. To go back also to Harsh, what are from your also previous expertise, experiences and your current research, certain practical challenges you see, or maybe even also opportunities?
So unfortunately, organizations are really reluctant to go on the record. So all the stuff that you get is through probing or just offering to buy them coffee or beer or something. But the reality is that, a lot of the times we don't know the information, like even they don't know the information. So I think there's a bit of a problem here in terms of how do we actually operationalize. And while we were discussing idioms, I actually discovered a new one called impacting two rights with one system. So given the context, I think that's a better idiom because, oftentimes the systems are not just impacting one aspect, they're impacting several aspects at the same time. And there's a thing that, I've addressed bias, I've secured, encrypted my data and I'm okay, which kind of gives you a false sense of security. So it's not that, there's a lack of expertise, it's that the expertise needs to cover so many different things that at some point you're not going to be able to do everything by yourself. And I think that's the biggest challenge to operationalizing FRIA. Also, getting more expertise requires more money. So, it's not like we can just say get more experts. Sometimes there's no budget or the budget is not actually available for getting these experts. So I think even sometimes when the organizations want to know more things, they are not able to, or that they don't have the decision-making or budgetary power to do this. And what ends up happening is that they rely on the vendor to basically give them the assurances that, everything is fine and don't worry, it's accurate or it's safe or it's respecting fundamental rights or whatever. And then something bad happens and we discover that, okay, they just sold me lies. So I always ask, where did they promise? Was it in their marketing slides? Was it in the contract? So I think there's a whole cultural aspect here that needs to evolve to actually understand where things need to be. And we need people who understand these things to be in those organizations. So you need, in-house experts who will know whether the external experts are actually telling you the truth or not like to do everything in-house. The other aspect is that most of the times AI systems operate in very similar manner at a broad enough level that you can actually share the expertise across public bodies and institutions. So I fully support, for example, Carolina's suggestion that maybe we have an external pool that is set up by the government for all the public bodies, and this way the budgetary solution, I think, can also be resolved. The other problem is more an information problem, that the organizations that set up AI systems in-house or set up basically a system that or product that has been provided to them don't have enough information to make informed assessments. So they rely on partial information given to them or just guessed by themselves to do impact assessments. And of course, those impact assessments then don't reflect the reality. They don't cover everything because the organization is not in a capacity to even understand that they don't have all the information. So this, again, I keep saying procurement, but unfortunately, that's the only legal way to get, things in writing. And to be honest, I've faced barriers getting organizations to even agree that procurement processes need to change because for them, it's such a bureaucratic hurdle that they would rather, just wait. So I think there's a problem in the sense that there needs to be a mechanism for the vendor to participate willingly or unwillingly to actually help you with these things. A lot of vendors do help, but then, they need an incentive, which is economic. So not just the product, but also assurances need to be given that, look, this is not just about performance. This is also about the due diligence of the public body that this is going to work correctly. But also if it works incorrectly, I can do something about it. That I can detect it, I can fix it, and I can go back to the vendor and say, okay, this happened. Can you prevent it again from happening in the future, in the next version? So all of these things, I think, will evolve over time. But just because I'm a bit of a skeptic, I would like to see them in contracts rather than, as pinky promises. And this brings me back to the last point, which is that the objective of the AI system when deployed by public body obviously is benefit to the public, but otherwise it's kind of pointless. But this does not mean, it's just about efficiency or performance or fastness. It's also about trust and assurance. That good that the public body can handle more requests, but can more data subjects or can more citizens avail of these benefits at the same time? And can they trust this system or not? So I think this aspect is not actually discussed when conducting FRIAs. We're only thinking about public bodies, but citizen participation as a way to build this trust or to make sure that the public body is aware of what can be the challenges is also something that needs to be operationalized.
Thank you. Staying with you for the very last round, very quickly, I would like to ask each of you to shortly reflect on where do we go from here. Harsh, starting with you.
I think we have to learn a lot, and I don't mean I want to do a second PhD. I don't, but we have a lot of learning to do in terms of how to deploy public AI in a sense. And for this, we need to build basically our own mechanisms, which are not currently available on the market. So, for example, the expertise, the sharing of knowledge across institutions. But at the same time, we have this unique opportunity that because of the common law in the form of the AI Act, there are 28 member states and maybe more in the future that will have the same problems, will have the same use cases, will have almost similar vendors. And this gives the opportunity to maybe have some collective action. Both can the organizations share what are the challenges, can they share how to address them, but also if it's the same vendor, each organization doesn't have to go to them individually. They can have collective power to bargain, and which gives also an incentive to the providers to actually fix it, because now more countries or more public bodies will buy or procure the system. Unfortunately, the AI Act doesn't say anything about this, but that doesn't mean that we cannot set it up. The last part is that how do we actually achieve this and how do we actually test it? So we have this little bit of a grace period in the IX implementation, and we are hoping that we get the FRIA template soon enough, for example. And I'm a big fan of actually testing it with the official documents rather than just arbitrary discussions. So we can actually take the FRIA templates and go to the public bodies for each of the Annex 1 or 3 clauses and say, let's try this FRIA template out, and what do we learn, and then we go back and improve so that they at least have a baseline for what to do, rather than asking them, here's an empty form, fill it out. No, you're wrong. Now we give them a little bit of a better informed form that says, choose from one of these. What are you trying to do? So we need this iterative approach of getting that FRIA in a shape that on day one, we will succeed.
Yeah, thank you for saying that. Also, maybe good to mention on the we as the Dutch DPA are also planning on facilitating pilots with the concept template to be provided by the AI office for exactly also this reason, also from a Mosaic perspective, to practice and see like what comes out of this documentation requirement and what can be improved, and also what would be, where can we then from our role and responsibilities contribute to relevant guidance in the Dutch context, of course. So thanks for that. David, where do we go from here?
Yeah, quickly, I agree, of course, like testing is relevant and we also hope to contribute to that. I think we really need more concrete examples and research on risks in specific use cases. This abstract theoretical discussion of fundamental rights risks and AI, I'm almost a bit tired of because it's easy and it's for many years, but we really want to see on specific use cases because that's also where you can progress. We need more also on understanding how you can mitigate those risks. So our report showed that there's no structured approach to mitigation measures. There's some sort of over-reliance on human review. So people always say, oh yeah, human is checking the output, so it's all fine, which is not always a good solution. So that would also be good to just learn more, and also about like sort of red flags or like what systems are really not fit for purpose, and to learn more to also help then others in the future to know where to go when they want to use AI. Last sentence, just concretely, next steps also, apart from us as the Fundamental Rights Agency trying to contribute to the standards development with Sensenelec, also, of course, cooperating as much as we can with the AI office, with the AI board subgroups, and see also seeing. I just wanted to mention one more is Article 77, right? That's the fundamental rights protecting bodies that have access to the documentation drawn up under the AI Act. And that's a very relevant way. So we intend to work also with Article 77 bodies. There are 208 now, accordingly appointed. And they have access to the documentation drawn up under the AI Act. But there's still a lot of questions. And that's what we also want to promote and work with. There's the AI Act Advisory Forum, where we are a permanent member alongside the Cybersecurity Agency and the technical standardization bodies, Sensenelec, and the other one, ETSI. And then there are rotating members from civil society, academia, and business. And yeah, when it's set up, we also try to contribute there to the proper implementation of the AI Act. And yeah, lastly, I'm of course happy to see how we can cooperate with MSAs because they have an important role to also see how to assess then if the fundamental rights assessment was properly done in practice. And that's why I'm happy that you organized this panel.
Thank you. Last but not least, Carolina, where do we go from here?
Sure, I would add just huge +1 to the lessons learned, the need for exchanging lessons learned, and the question, whose responsibility should it be to facilitate that? And also huge +1 to piloting. The one good thing, if I have to find one good thing about the AI Omnibus, is that it bought some time to actually make those pilots possible. So I think this is something that I'm sure civil society would love to also contribute to. And then I have a question. How do we leave room for learning and for exchanging while simultaneously not forgetting about accountability and justice in case of human rights violations? So ensuring redress for people who are actually affected by these violations. And that leads me to my main point I wanted for this closing. I feel like often, we talk about FRIAs especially in this community of practitioners and as a process, and we discuss the nitty-gritty. But I want to take us a little bit to the political level right now, and maybe with a sad statement that we are currently living in a moment of crisis of rights-based approach, and that's a fact. And we are seeing harmful systems being deployed even after impact assessments have been conducted. Systems that stigmatize, discriminate, even when alarm bells are rang internally. And I'm sorry for bringing the Netherlands up again, but for instance, just to give an example of the AI system that was being used for assessing short-term visas, where internally the Data Protection Authority was saying it's discriminatory and unacceptable, and the Ministry of Foreign Affairs decided to ignore that advice and go with it anyway. So we are in this context, and we have to remember that we can have a perfect impact assessment process if we don't bring it back to this political level of political political choices, it will not be helpful. And to end on a more optimistic note, I see, for instance, a huge importance for FRIAs in that context to be a tool of accountability, to show these gaps and unaddressed risks. And here, for instance, clear expectations as to what needs to be published in the FRIA summary in a way that is actionable for people who have been affected, in the way that is actionable for civil society watchdogs, that will be extremely important. Of course, we will not directly see that for law enforcement and migration, because that was the political choice that was made. We will only have to rely on institutions. But as you said, I think we have allies in the Article 77 institutions who can also look into that. So for me, that is a very, very important element of the next steps. How do we set expectations for how deployers communicate about what they did?
Thank you. We're a little bit running out of time, so I'm going to leave the panel at this. And before I open the floor for questions or insights, I would like to give the floor and invite Makis from the European AI Office to share some reflection, and I understand also some updates. Yeah, there's a microphone there.
Can you hear me?
Yes.
Yeah.
It works.
Okay. Thank you very much, and thanks a lot, that CPA, for inviting us here. Minding the time, first of all, just maybe for people to know how the AI Office fits in this picture, is that based on the EU AI Act, Article 27, we have to develop the template to facilitate the FRIA process. And this is something that we are actually working on together with FRA, but we have received a lot of inputs, and we are very grateful about it. Okay, sorry. You know, it's strange to have also a panel and a portable microphone. And of course, we are always keeping an eye on the work of the civil society, of NGOs, of think tanks that have worked on the field, like ECNL. And we are really trying to have our doors open to feedback. The current state of play is the following. As you may have known, we had a few days ago, the omnibus was concluded. For people familiar with bureaucracies, having an omnibus process open takes a lot of space and a lot of resources. So now we are in a phase that we feel a relief, and we can focus more on deliverables like the FRIA template. We have a change that is the application date. As you may know, initially the high-risk obligations, including the FRIA, was to start on 2nd of August 2026, and now the new date is December 2027. However, our ambition, and I would like to underline the word ambition because sometimes it's a bit difficult to be on time, is to move things forward, because we have already been prepared for the August deadline. The current state of the template is that, let's say, it is in the final stage of internal validation and reviews, which maybe sounds like it means nothing, but it means something. And our ambition is to go for a public consultation in June. We are a bit skeptical if we are going to finally make it, but what we want you to keep is for sure that this template is going to go in a public consultation. The template that you are going to see is going to be, let's say, a paper version, like a traditional word-based template, because this is the simplest way to go out for a consultation. However, as you can see also in the Article 27, our mandate, let's say, is to create an automated tool. So this is a work that happens in parallel. We are trying to find the best, let's say, infrastructure to do so. Just we need a paper template to fit the discussion. What else I can tell you? The omnibus, as was said before, didn't change much, just enhanced, let's say, a bit the call to link things a bit with the DBAI. What I would like you to know is that we are really listening and we are really trying to get as much feedback as possible. We already did this also through the AI board and the subgroups, and that's why also a next step, we will see how this will play with public consultation, would be a testing, but we are also considering together with FRA. We will see also if we can have other stakeholders, some sort of piloting. We will see how it will work. But what I want to, let's say, signal from our side is that we also see FRIA not as a template, but as a process. We are trying to do our best in order to build something that will not, let's say, easily allow just to take a template, fill it, and submit it. We believe that also this is a job, a task, let's say, to be conducted by an interdisciplinary team, if possible, as it's not a pure legal or legalistic compliance play. Of course, we are not a fundamental rights, let's say, entity. We need also to build something that works for 27 member states, which is a difficult exercise. And we are trying also to build something that is lean and efficient. Just as a last comment, FRIA is better maybe to be seen as part of a check and balances dynamic. It's a hook that exists in the AI Act, about which we are very happy that it's there. Indeed, despite opposition during the negotiations, it's something that is to be submitted in a market surveillance authority. The market surveillance authority has to act on it, and let's not forget also that eventually the courts are going to come in play. We need time to build some institutional memory and, let's say, some sort of jurisprudence. So it will not work perfectly from the beginning, but we believe that on the long run, this is a system that will really act as a safeguard for fundamental rights in the EU. Thank you.
Thank you. Still processing many reflections, but maybe I think it's time to open the floor for the last 15 minutes as well. I see hands up in the back, in the front. Okay, so let's start in the back and walk forwards. Is that okay? Thank you. And also thank you for helping.
Hello, thank you so much for this session. It was very interesting. I wanted to ask a question also to David and Carolina, because you both said something, I think, about the limiting bias that can be reduced also using AI and also reflecting with AI. And also, Carolina, I think you mentioned that there is in law firms, but also maybe broader within the government, we have too little information on human rights in general. And I was curious about that with the arrival of AI, we're actually starting to look at human rights impact of policies in general, though we are already making policies and decisions from a human perspective for a long time that also have bias and that can also affect human rights. So my question to you is, isn't it possible? Wouldn't it be smart to actually broaden the scope of the FRIA and look into more human-made decisions as well and inform people more about human rights in general?
Thank you. I want to suggest to collect 2 more questions and then go into the answers. So, hands there. Yeah, that's okay.
Yes, thank you for the presentations. My question goes to Carolina. I'm wondering, I agree with your observation on sort of like the crisis and the growing, increasing impunity, lawlessness that is taking place. In the Netherlands, there was also an interesting example of an impact assessment where they said, well, we don't have a legal basis, but we're willing to accept the enforcement risk. And I'm very curious if you have any ideas of how to increase accountability within this area. And maybe the other speakers also have ideas about it. So I'm curious to hear about that.
Maybe one more. We'll have a second round after this.
Just a sort of comment. Usually, academics are considered as being an ivory tower, but it seems to me that we are not alone in the ivory tower, because we are still discussing in general about fundamental rights impact assessment, while there are models that are running since at least 2 years, one in the Dutch Ministry of Interior models that have also some specific case, and the other one, the model that we have adopted in Catalonia, that has already implemented in real case and make available and also adopted at international level and tested in 3 different countries outside of Europe by United Nations. So I'm a bit surprised that we discuss in general about impact assessment in fundamental rights. As well, I'm surprised that the AI office tells that it's open and listening, but imagine that listening means start looking what is around and starting what are the experiences that are on the table, rather than adding new models and new templates. So, to be frank, it's an observation, but it seems to me that when there are cases already implementing models, maybe it would be useful starting from this experience, because many things that you say, for instance, about the role of a provider and deployers, about public procurement, etc., if you know the real world, if you know how these cases are implemented, you realize that something is just a dream and other things are possible to a certain extent. So this is a general comment. I want to highlight also that only the Fundamental Rights Agency focus on the real cases, because in the report that issues in December 2025, make express reference to the existing models as models that can be considered. Unfortunately, the AI office is not so open to this discussion and adopted a template without any exchange with the experience existing, and putting the template then under consultation.
Yeah,
we are a bit tired about this consultation.
We're also limited in time.
Yeah.
I understand the point you're making. Thank you for adding that to the conversation. I think let's continue with the first 2 questions and then maybe also respond to what's been said. And then we do another round. Thanks. So I think, yeah.
I'm happy to start. I would pick on 2 questions. The first one on debiasing. I mean, I don't think it's about debiasing. That's another big discussion. But I think the opportunities that through checking AI, we learn a big deal about human rights violations, right? There's the case everyone knows. Amazon tried to use an recruitment algorithm, and they found, surprisingly, not surprisingly, it prefers men over women. Of course, it's just reflecting the recruitment practice from before. We have a lot of hard data that recruitment is, for example, also quite racist. You know, there are a lot of situation testing, as it's called. You send CVs, you only change the name, and if it's a Muslim-sounding name, people get lower callback rates. So we know this is happening, but apparently we need more and more evidence to actually prove that. And their AI is actually a good chance to also do that. And then, and that's a bit daring, we need to see like how we can take this further. Like in our research, when we ask people why you use AI, almost everyone always said like, oh, for efficiency reasons. We have no resources. We have to do things quicker. And we were always surprised saying like, why don't you say we want to do things better, right? We really thoroughly analyzed, and we know there's a lot of human bias, but now with automating this, we may aim to make a fairer system in practice. That's what I would like to see much more, but it's still ongoing. But at the same time, like at least an assessment phase of AI use also to actually highlight fundamental rights violations in practice for those, because a lot of data and evidence is still needed in practice. Yeah, and just quickly reacting, I mean, to the comment on existing models. I mean, as I said, there is a lot of models out there, and it's a long-standing discussion, and a lot of knowledge. I think that is also built on in practice. The other thing is just what the reality of law looks like. Like the AI Act is the result of a democratic process, as I like to say. And it has different elements where fundamental rights are impacted on, and now these are operationalized in practice through standards on the one hand and Article 27 on the other. What I still overall want to say, because I think all the templates out there are useful, but I really think, and now speaking at CPDP, also like to legal experts and human rights experts as well, we have to do a better job in translating rights into practice, because it's not always the computer scientists who speak language that we don't understand. They have to be clearer because they need to tell how a system works. But that's also where the human rights people need to explain what a right means in practice. You cannot come with citation of case law in all directions. That is, of course, your job. But in practice, like what it means, and that's also where the tool can help in practice to operationalize this. Yeah, that's just where we can go from here. But as I said, there's a lot of experience that we can build on and should be used in practice. Yeah.
Yeah, very quickly reflection on the first question. I think it's important to consider where human rights violations can actually stem from. Like they can stem not only from data, they can stem from data also, but they can also stem from assumptions on which the system was built. It can stem from actually the process in which, as part of which the system functions. For instance, in the public sector, does the person have redress? Is this civil servant who's looking at redress, do they have enough power and also literacy to challenge an AI decision? So I feel like we need to look beyond, the technical means of mitigation for sure. So I agree. I guess that's what your comment was going, to look beyond data and look at the organizational culture and the process as well as part of the FRIA. And then on the crisis and how to increase accountability, I think this is an evergreen question in general in like business and human rights discussions as well, beyond AI, beyond tech. So it can be quite daunting sometimes to get actual accountability. Something where I do see, and I think that is a double-edged sword of mandating certain human rights due diligence. I do like the fact that the AI Act for the first time in the EU actually makes human rights impact assessment mandatory. But that can go in two different directions. It can go either in the direction of compliance mindset, where I do the minimum viable product. I don't want to expose myself. That is a risk that it might go in this direction, which is not necessarily going to help accountability. But then the second direction is that actually this will create an incentive to take human rights more seriously, and it will create accountability. So for me, it remains to be seen. I'm also very often impatient to see the results of accountability. I do, however, think that we will be able to use FRIAs for cases also actually under other laws, not necessarily under the AI Act, because the AI Act redress mechanism for me is still not clear in terms of complaints to the Market Surveillance Authority, how effective they will be. But we can use the information from FRIAs for other avenues, for the GDPR, maybe for collaboration with national human rights institutions who have the mandate to access those as well. So and then to use that information also for public campaigns and public pressure. So I think that the mere existence of FRIAs will then lead to possibility to explore other avenues for accountability. So that's my hope, and that's what we will be working towards. But we'll see in 5 years where we are.
Thank you. I guess it's a date in 5 years back here at CPDP. I also want to give Marcus the opportunity to respond because there was also a comment made directly at the AI office.
Yes, thank you. Actually, sorry, because I didn't see who spoke, so I'm looking randomly. Very quickly, I mean, I think I'm the last person that will going to be, reluctant to accept criticism to the Commission. But I think we have to be careful, not to use some, let's say, historical arguments against bureaucracy in cases that they don't fit. For example, the main criticism about the AI Act is that Europe this time acted very early. The technology was still developing, the technology was developing outside Europe, so we rushed to regulate things. And to be very honest and very frank between us, the fact that we also had an omnibus before even the full implementation of the Act also shows, let's say, how this has been perceived. Being in an ivory tower, I think this is a habit of bureaucracies, but in our case, to be honest, if you see how the AI office works, we have the AI board, we have subgroups, we have 27 member states in very different capacities, in very different expertises from, let's say, all the ministries, that they are in constant communication with us. We have Article 77, but we have all the fundamental rights. Yeah.
The advisory forum?
The advisory forum, but I just
Where is
also wanted to say that I think in the next weeks you will have news. So I don't think on the specific one. We live in an ivory tower. And one last thing, when you are addressing 27 member states, your aim is to provide legal certainty. So you are looking of projects or things that work. For example, also the Netherlands has a very advanced process similar to FRIA. We have discussed about algorithmic assessment in general, but it's not so simple to provide a plug-and-play solution for 27 member states with very different also capacity to absorb new regulations. So I think we have also to be a bit fair, but on the other side, to be honest, when it comes to fundamental rights, I think every pressure that you can put on us at the end of the day is helpful and productive. And this is also what legal tools like the FRIA and Article 77 provide to the civil society, to the citizens. Thank you.
Thank you. I know I said a second round of conversations, but they were really persistent. And I think that's because there is another event happening here with just 5 minutes time in between. So I'm really sorry to say that there will be no questions. 3 minutes?
We have.
Okay. We want to go up until the end. But then this is the challenge, to have very specific questions with very specific answers and short, please. I saw your hand earlier, and there may be 2 more. Thanks.
Okay. Hi. Thanks. It was great. I have a question because I'm working on a FRIA Plus, as I call it, the PIA incorporated in the FRIA. And one of the things that we were talking about is it's difficult to predict what's going to happen with certain type of AI that you're using. And I think that's also because this process of the FRIA is now executed by a lot of lawyers. And I think that was previously stated by the IOSs as well. I think it's preferable that we have an interdisciplinary team. But I work at a legal service provider in the Netherlands, and a lot of our clients are small. They're small. The lawyers don't have that many people. So I was actually wondering, like, twofold question. First, what would you advise? Who would execute the FRIA? And what kind of expertise would you attract to help in this prediction of which fundamental rights might be impeached? Because I have ideas about that, but I'm really curious about what you say.
Yeah, and there will be enough. I think we should leave it at that for now, so we can take 2 more quick questions. And I mean, this is not where the conversation stops. I hope this is a starter. We have until tomorrow where we're all here together. So do please find us, find each other. Yes.
Yeah, I will be super quick. My question is about participation of impacted stakeholders. Participation of impacted stakeholders. That's one
Sounds
question.
like a big statement.
But
yes.
the point is, it's for capacity building, but it's also because fundamental rights are not something that just judges can, but the interference needs to be checked on the impacted people. It's a fundamental right imperative. Are you doing something on participation of impacted stakeholders?
Thanks. One last.
So quickly, in the context of accountability, do you think that in practice we can make one document that can articulate the GDPR, the data protection impact assessment with the FRIA?
Thank you.
I'll be very quick. Combining the first 2 questions somehow. I mean, of course, guidance is needed also for smaller companies to do that. But obviously, to prove that you took it seriously is to engage with stakeholders and affected groups. So that's, as we also highlight, an essential tool to achieve that you actually, because you have to prove that you seriously looked into these issues. Talking to affected people, to experts, to stakeholders is one way to prove that. So that's quite an essential point. Having one document, I'm afraid, is not a political reality. Although it could be. There's a data protection impact assessment template out there for consultation at the moment. I hope, and there will be ways how they speak to each other, at least.
Thank you.
I don't know if Milanas wants to address the participation question.
On the participation question, we can even, discuss after this. We have a lot of groups and a lot of parallel processes, And just to say, because I think it's very good news, that after the omnibus, the new Article 77 that has to do with fundamental right authorities, we don't even have the restriction anymore of high risk, as was in the past. So we are planning as an AI office to build on this. There is already networks, but there are many things that are being channeled through the member states, let's say, through the AI board. The advisory forum will be a reality in a few weeks. So I can say confidently that sooner or later we are going to address this need. Yeah.
Okay, thanks.
No, no, no.
Okay.
Do you have a last? This was the last point. A bit chaotic at the end, but this only means that there is so much to still discuss. Thank you all.